Welcome back to Nyay Patsala. In part 2, we are going to explore the intricacies of confession both during trial and investigation. In part 1, we have discussed the statements and admissions which you must have already looked into. To save time, we will be referring to the sections of the CRPC but will not read the entire section. Kindly keep your bare act in hand so that you can read what is section 164 CRPC. Because section 164 CRPC provides the procedure for recording of confessions and statements. If I read each and every statement that is made under section 164 CRPC, it will make my video very long. So I request the viewers that kindly look into you can pause the video at this time and look into 164 CRPC. Then after that I will discuss each of the important points in relation to confession. So first let us understand what is confession. Listen carefully. A confession is an admission of the offence by the accused, whereas an admission is a statement, oral or documentary, which enables the court to draw an inference as to any fact in issue or relevant fact. You must remember that there is a clear distinction between admission and confession. The term admission is of wider connotation and can be used to include a confession, whereas an admission made at any time by a person charged with a crime where he states or suggests the inference that he committed a crime. So all confessions are admissions, but all admissions cannot be confession. If the admission is sufficient to prove the guilt of the maker, it is a confession. You may look into the judgment of the Supreme Court in 2005 11 SCC 600, that is the Parliament attack case, which is state within bracket NCT of Delhi versus Navjot Sandhu. Next query that definitely comes to our mind is that how can confession be classified? Confession can be classified into two types. Number one, judicial confession, and number two, extrajudicial confession. Now what is judicial confessions? Judicial confessions are those which are made in the presence of a magistrate or inside the presence of a court. So judicial confession, remember, it is made before a magistrate or inside the campus of the court. And it can happen during investigation and also during trial. If it happens during investigation, then section 164 CRPC would come into play. You must remember that sometimes the accused who wants to record his statement under section 164 CRPC is not sponsored by the police. In that case, you look into the judgment of 2001 7 SCC 148 Mahavir Singh versus State of Haryana, and also look into another judgment 2000 volume 1 SCC 272 Jogendra Nahak versus State of Odisha, where the victims and witnesses when they are not sponsored by the police, what will be the outcome. And in case of summon case, how the confession has to be treated during trial, kindly read section 252 CRPC, and in case of warrant case, kindly read section 241 CRPC. Now let us understand what is extrajudicial confession. As I have already told, the judicial confessions are recorded before a magistrate or it must be made inside the court, whereas extrajudicial confession is recorded outside the court. It may be to a police officer while in the custody of a police officer. But here certain inherent limitations are there, which is provided under section 24 to 27 of the Evidence Act and section 163 CRPC. We must remember that a police person or a police officer is a person in authority. So before a person in authority, you must first see that there is no threat, inducement or promise to make a statement. In this case, you will refer to section 24 of the Evidence Act. And if confession is made before a private person who does not prompt and who doesn't have an oblique motive, then the court has held that his testimony should be credible and free from blemishes. The next question that comes up into our mind is that who can record a confession or a statement under section 164 CRPC. As I have already told that under section 164 CRPC, the magistrate can or judicial magistrate can record a confession. Sometimes the police officers are also provided the powers to record confession. Then the police officer can record the confession. But in case of an executive magistrate, there is a legal bar and it is not acceptable to record the confession before a executive magistrate in terms of section 164(1) of the CRPC, and the courts have held that this is inadmissible as an evidence. You can look into, in this case, you can look into AIR 2000 SC 290, that is Assistant Collector of Central Excise versus Duncan Agro Industry Limited. And in case of police, your officer on whom the power of a magistrate has been conferred under any law, then in that case the police can record a confession under section 164(1). The next query that comes up into our mind is that statement under section 164 CRPC should always be recorded by the magistrate or the jurisdictional magistrate. If you read at section 164 CRPC, it will not be illegal if some other magistrate records the confession or statement under 164 CRPC. But he should see that the precautions or the safeguards that is provided under section 164 CRPC is available to the accused. So it is not necessary that in a court that particular Eleka magistrate or the jurisdictional magistrate will only record the statement under section 164(1) of the CRPC. It can be recorded by any other magistrate of that court. The next point you should remember is that at what stage a confession or statement under section 164 CRPC can be recorded. As I have already told you before, that confession or statement under section 164 CRPC can be recorded either during the course of investigation or at any time thereafter, but before the commencement of inquiry or trial. Now let us try to understand that can an accused on his own give an consent or an accord to make a confession without being sponsored by the police? Yes, the accused can himself appear before the judicial magistrate for recording his confession. But the court should see that such accused person is free to make a voluntary confession before the magistrate, and he is not sponsored by the police, unlike in a case of a witness or a victim. This is of course a judgment law, and the only rider is that before recording the confession, the magistrate should be satisfied that the person who proposes to confess, number one, is an accused, and number two, investigation against him is in progress. You can look into one of the judgment, that is Mahavir Singh versus State of Haryana 2001 7 SCC 148. While recording the confession, the magistrate should always see that the accused is free from any police or other extraneous influence. The magistrate should take care to see and must be satisfied that the accused is not sponsored by the police and is free from any police or other extraneous influence. While recording a confession by the magistrate, the query that should crop up is that is not a confession liable to be discredited merely because the accused is produced from the custody of the police for his recording his confession, or the sub-jail from where the accused is produced is located adjacent to the police station? The answer to this query is no. Just because a person is produced from police custody before the magistrate for recording his confession, such confession cannot be discredited. But the magistrate must take into consideration the fact that there was an interval of about a month after the accused was removed from police custody to judicial custody when his confession was recorded. And in one of the cases, the Supreme Court has accepted the confession as voluntarily made under such circumstances. You can look into 2000 volume 6 SCC 269 paragraph 19 and 20, State of Maharashtra versus Damu. The next query that comes up to the mind is the accused to be warned against making the confession? Yes, the accused must be warned against making the confession, because before recording the confession, the magistrate shall explain to the person making the confession that he is not bound to make a confession, and that if it does so, his confession may be used as evidence against him. You can refer to section 164(2) CFPC. This provision emphasizes the need for warning and caution before recording a confession under section 164 CFPC. The next question that comes up into our mind is that should the magistrate be satisfied about the voluntariness of the confession? Yes, the magistrate shall not record the confession unless after questioning the person making the confession, the magistrate had reason to believe that it is being made voluntarily. Because voluntariness of the confession is the foundation of the magistrate jurisdiction to record the confession. So it is imperative that the magistrate should, before recording the confession, ascertain through intelligent questioning whether the statement is spontaneous and voluntary, or sometimes the influence of false impression has been at work to induce him to make the statement. These are some of the things which the magistrate should ascertain before recording a confession. The next question that comes up into our mind is that does the magistrate have the power to administer oath to a person before recording his statement under section 164 CFPC? While reading section 164 CFPC, you must remember the distinction between statement and confession. While making a statement, the magistrate can administer an oath. But while recording a confession under section 164 CFPC, no oath can be administered. These are the 2 points. Kindly remember when you read section 164 subsection 5 of CFPC. The next query is that whether the statement of a person under section 164(5) CFPC be recorded in camera. In one of the judgment of the Supreme Court, it says yes, statement of person including witnesses and non-confessional statement of accused person should be recorded in camera. This is done because by way of protection to such person, the culprits may not come to know of the recording of such statement, and therefore they will have no occasion to harbor any rancor or vengeance against such person for giving such statements. As I have already told that statement under 164 CFPC cannot be given to the accused until the stage comes where under section 207 and 208 CFPC copies are given free of cost to the accused. The next query that comes up into our mind is that should the magistrate allow any time for reflection to the accused before recording his confession under section 164 CFPC? Yes. Before an accused is asked to make his confession, the magistrate should ordinarily allow a period of reflection and remand him to jail custody so as to put him out of the reach of the investigating officer. The object of keeping the accused or the suspect in judicial custody and giving him sufficient time for reflection and necessary warnings, because it reinforces the voluntariness, since with the sufficient time given for reflection, the accused frees himself from the presumed pressure of police interrogation before making the confession. So what is the time limit that should normally be given for reflection? In most of the cases, it is said that 24 hours is sufficient time for reflection of the accused to make a confessional statement, whereas 5 to 10 minutes time given for reflection is not sufficient. That has been observed in the various judgment of the Honorable Supreme Court. The next query is that should the proceedings of the magistrate recording the confession be in open court and during court hours? The answer is yes. The magistrate should record the confession only in open court and during court hours. So what is the manner of recording the confession? You should look at subsection 4 of section 164 CFPC, which mandates that a confession should be recorded in the manner provided under section 281 CFPC. It has to be signed by the person making the confession. The magistrate has to make a memorandum as given in section 164(4) CFPC at the foot of the record to the following effect. He should give an endorsement like saying that I have explained to so and so that he is not bound to make a confession, and that if he does so, any confession he may make may be used as evidence against him, and the magistrate believes that his confession was voluntarily made, it was taken in his presence and hearing, and was read over to the person making it and admitted by him to be correct, and it should contain a full and true account of the statement made by the accused. The query that is often asked is that should the record of confession be signed by the accused and the magistrate? The answer is obviously yes, because the record of the confession shall have to be signed by the accused as provided under section 164(4) CRPC and by the magistrate as provided under section 281 1 and 5 of CRPC. Why is this requirement? Because the requirement is of obtaining the signature of the person making the confession is mandatory, and non-compliance thereof sometimes renders the entire confessional statement inadmissible. But sometimes such non-compliance may not be very material if the making of the confessional statement is not disputed by the person concerned. But non-compliance with section 164 CRPC sometimes goes to the root of the magistrate jurisdiction to record the confession, and the Supreme Court has held that in such circumstances it renders the confession unworthy of credence. For that, you should also look into the later part of section 29 of the Evidence Act while appreciating a contention of non-compliance with section 164 to CRPC. So, at this stage, let us look into what is the language in which the confession should be recorded. This confession shall be recorded in the language in which the accused is questioned, or if that is not practicable, then in the language of the court. Kindly read section 281(3) of the CRPC in this regard. And as I have already told you that for recording a statement under 164 CRPC, oath may be administered. But in case of recording of a confession, oath is not required to be administered. After recording of the confession by the magistrate, he forwards it to the jurisdictional magistrate who has the power to try that offence. So now let us understand what is the evidentiary value of a confession. A confession is ordinarily admissible in evidence. Please remember, it is a relevant fact. It can be acted upon, and under certain circumstances, it can even form the basis for a conviction. And a confession, whether it is judicial or extrajudicial, if found to have been voluntarily made, can also form the basis of conviction of an accused. But if you look into the word confession, you will find that it is not taken in the definition of evidence under section 3 of the Evidence Act. So it can fall under the expression matters referred to in the definition of the word proved in section 3 of the Evidence Act. Therefore, confessions, notings made by the presiding judge upon a local inspection, material object, etc., are covered by the said expression matters. And we must remember that while recording a confession, is it necessary to examine the magistrate who recorded the same, or non-examination of the magistrate can cure the illegality in case the confession is not in conformity with law? We must remember that a confession is admissible without examining the magistrate who recorded the same. And if the confession is not in conformity with law, even the examination of the magistrate will not cure the illegality. At this stage, you must also look into the relevance of a retracted confession. In case of retracted confession, just remember, merely because the confession was retracted later, it does not mean that the confession was not voluntary in nature. Because the issue is whether the accused was willing to give a confession voluntarily or not is to be determined from his mental state at the time when he gave the confession. If the confessional statement has been amply corroborated by circumstantial evidence, his subsequent retraction by the maker would not make it unreliable. So to conclude, today we have discussed the scope of section 164 of the CRPC vis-a-vis the case laws of the Supreme Court, as well as certain provisions of the Evidence Act. It is necessary to understand the difference between statement and a confession. the difference between admission and a confession, and I am sure that this effort of Nyay Patsala will help you in understanding this concept better from the practical point of view. With these words, I once again request you to subscribe to our channel Nyay Patsala if you like our content, because if you support us, we are sure that we will come up with more useful legal topics from the practical point of view.